Hello everyone, I am Aditya Sharma from Law Mantra and today I am going to tell you about the Article 32 of the Indian Constitution. The Article 32 of the Indian Constitution enshrines this provision whereby individuals may seek redressal for the violation of their fundamental rights. Article 32 Constitution of India. It grants an extensive original jurisdiction to the Supreme Court in regard to enforcement of fundamental rights. The significance of Article 32: when a person feels that he is unduly deprived of any of the fundamental rights, he can under Article 32 of our Constitution move the Supreme Court for a legal remedy. The Article 32 has four parts. First, under Article 32, an aggrieved person can move the Supreme Court for a legal remedy in case of an alleged infringement of his fundamental rights. In such case, it is the constitutional duty of the Supreme or Apex Court to look into the matter and provide necessary redress to the affected person. Secondly, in such case, the Supreme Court protects the fundamental rights with the help of the constitutional weapon of writs. So when an aggrieved person eagerly moves to the Supreme Court under Article 32, it has to protect the rights by issuing an appropriate writ for the restoration and maintenance of the rights unduly curtailed by any other person or authority. Thirdly, the Parliament may by law empower any other court with such authority so that it too can act as the protector and guarantor of such rights. Fourthly, Clause 4 of the Constitution, however, mentions an exception. When the President proclaims an emergency under Article 352, the provision for guaranteed remedy for fundamental rights remains suspended. In such times, the President may under Article 358 make a separate proclamation by which Article 32 remains suspended. During an emergency, the enforcement of fundamental rights should remain suspended because the unrestrained rights of the individual might in such times endanger the security of the nation as a whole. But in normal times, fundamental rights seem to be fundamental. In the case Ram Singh versus Delhi, the Supreme Court observed, it is our privileged duty to see that rights which are intended to be fundamental are kept fundamental. However, J. Sastry similarly claimed in the case of Roe versus Madras that they were sentient on the qui vive, and hence it is their burden duty to save the rights from being ruined. Thus, as judicial sentinel of fundamental rights, they are equipped with some constitutional weapons known as writs for the enforcement of such rights. The constitutional weapons or writs are as follows. First, the writ of habeas corpus, meaning you may have the body, may be issued in order to set free a person who is in the opinion of the court arbitrarily arrested or detained by the executive authority. Second, writ of mandamus, meaning we order the Supreme Court and issue this writ for the reason of directing an inferior court or department to do the needful for protecting or maintaining a fundamental right. Third, writ of prohibition, an order from a superior court to a lower court or tribunal directing the judge and parties to cease litigation because the lower court does not have proper jurisdiction to hear or order or determine the matters before it. Fourth, quo warranto, a writ of legal action requiring a person to show what warrant an office or franchise is held, claimed or exercised. Fifth, certiorari, a writ of order by which a higher court reviews a case tried in a lower court, and this is also known as judicial review. Thank you very much. If you find our video useful and interesting and you really like this, kindly not forget to subscribe our channel. Thank you very much again.